Hey, guy.
Hey, guy.
Wait, I'm a gal.
You are, but I mean, we use Hey Guy as an homage to one of our dear friend's fathers, as kind of a tribute to him. Even though he's very much alive, he's gotten us in the habit of saying Hey Guy to each other, even though you are Hey Gal. So I'll do Hey Gal.
You should tell the story, though.
Yeah, my one of my best pals, Dave Caddy, his dad was always very generous. The family let me stay at the shore house, and he's just, I think he may not remember everyone's name, so he does a lot of "Hey guy," "Hey Mr. Caddy," "Hey guy." It's become a thing, and according to my friend Dave, this is how other people who have met him greet him, all in sort of a respectful tribute to Dave's father.
There we go, Mr. Caddy. Thank you very much for influencing all of us and how we greet each other.
Absolutely.
So, why don't you introduce the show?
Welcome to the Danny Savalas Show with my co-host, Sarah Ganem Savalas, or Sarah Ganem, or Sarah Savalas, depending on what administrative office you are visiting, where we cover all kinds of interesting stories in the news with a legal angle. How is that?
That was good.
And you also you kind of like the more real introduction. I do the TV voice guy introduction,
What
right?
does
You
that
probably
mean?
you probably prefer more of a "Hey everyone, this is what we're talking about." But I do
No.
more of the "Good morning."
No, I need something for underneath the music that we play, the
Oh,
introduction.
okay.
Yeah. So let's set the scene here. Second week of January coming to a close.
We had some celebrity legal news. We had Kiefer Sutherland who got arrested. Timothy Busfield was
Oh,
arrested. A couple of
such a
those
sad
cases,
one.
and then this au pair murder trial, which has slowly grown like a rolling snowball. Where I would say 2 weeks ago nobody had really heard of it, including me. And now 2 weeks in, people are realizing, why wasn't this on our radar sooner? So a lot of things. We've got sports indictments. We've got Washington Post reporters being raided with search warrants. It's not as crazy as it was the week before, but it certainly is pretty crazy.
Yeah, there's so much to talk about, and I know we're probably going to start with this double murder, which I think is really fascinating that you said people haven't heard of it. When you said I want to talk about this double murder on the show this week, I instinctively thought it was the dentist and the doctors. That's in Ohio, right? And you said
Ohio,
no, you
exactly
said
right.
you said no, no, that's the one everyone's talking about, but there's
Right.
actually one that's more interesting that you want to talk about. So I don't know that much about this case. What happened?
Yeah, this is the Brendan Banfield case, and I struggled to explain it part of the thing on TV, you don't have a lot of time. And one of the challenges I've found on this, along with the reporter at NBC covering it, Ellison Barber, is that it's challenging to describe what's happened in 30 to 60 seconds, but
Oh,
I'll
it's one of
try.
those. It's one
Yeah.
of those.
So
Yeah.
you have two victims, and maybe I'll start with what was initially believed. What was initially believed, although not for very long by law enforcement, I think they were skeptical early on, was that a man broke into the home of a married couple where their Brazilian au pair lived with them to take care of their baby. And the man apparently was responding to a fetish website connection he had made with the wife, and the wife had apparently told him to break into the house with a knife, tie her up because it was part of some fantasy. And even if I complain or struggle, don't give up. Keep going with the sort of fantasy and sexually assault me. And they had apparently met on a website, a fetish website, and this guy had agreed to come do this. The husband and the au pair magically show up right at the right time as the assault is taking place, and they both shoot the intruder. And it appears that the wife had been stabbed to death in the interim. What now prosecutors say happened is so diabolical, it's unbelievable. Within a year or so, they arrested the au pair. And shortly after that, sometime after that, she became a cooperating witness. This
Oh,
is
wait.
what
So
she
this
says
happened
happened.
a while ago. It took them a long time to figure out what actually happened.
That amazes me is that they were both free. Both the au pair and the husband were free. Obviously, the victim's dead. The intruder shot to death. I shouldn't say intruder because he may not have been. He may have been there invited. And the wife stabbed to death, at least presumably by the intruder. but police no longer think so. What instead happened, and unfortunately, it's kind of a bummer that, as soon as you say au pair, I've seen a lot of people's eyes, roll. This was a young, very young 21-year-old Brazilian au pair, and she had started a romantic relationship with the husband and father. And yes, these both of them were out free for I think a year, and police came back to the house for whatever reason and saw that she had moved into the main bedroom with the husband and just sort of taken over as mommy for the daughter. And even though that's not evidence of what happened in the night in question, that's the kind of evidence that's devastating for the defendant. So they arrest the au pair, charge her, and she enters into a deal. And what she testified at court was this, that she and the husband started an affair. The husband didn't want to get a divorce. He was worried he wouldn't see the kids, worried it was expensive, whatever. And it just blows me away, folks. What's wrong with divorce? What is this population in the true crime world where husbands get this idea that instead of divorce, I'll hire a hitman or I'll come up with this elaborate way? It never works. These are always the husband is the first person that is a suspect. You know that from covering umpteen million of these cases.
Yep.
So sure enough, the au pair testifies that he came up with this plan where the au pair and he would falsify an account on the fetish website from the wife, and the wife would find some guy willing to break into her house while she slept, because she slept, I think, during the day. She was an ICU nurse,
Oh,
and
geez.
wake her up and sexually assault her as part of her own fantasy. But she was never involved. The wife never knew about it, according to the au pair. It was all a ruse concocted by the husband. And what they would do is they would arrive in the nick of time, well, not the nick of time, and shoot the intruder dead so he could tell no tales. And then, according to the au pair, it was after they shot the intruder. And this is so sad to me that the wife probably thought, oh, thank God, my rescuers are here. And then, like a horrible thriller movie,
Wow.
these two end up being her killers and they stab her to death. I believe the evidence is that it happened after they had already killed the intruder, who, by the way, was a totally innocent, according to the au pair, just some guy who wanted to come over for some rough sex from the website, not a killer by any stretch, according to the au
Wow.
pair. So
So, and
it's
these
it's
guys get away with it. They think they get away with it for a full year. And
right,
it's
and then
kind
they
of by
arrest.
chance that the police figure
Yeah,
out that this is not what happened. So the police bought the story. That's
well,
crazy.
for a time they did, and I agree with you. The fact that it took them a year astonishes me. And by the way, it's the centerpiece of the defense's theory. And this is a case where the defense doesn't have much. I'll say that now, but I can go into that in more detail. So they're really pounding this home. And this is something you do as a defense attorney. If the investigation sort of sputters or struggles for a period of time, that's something you can use to your advantage. And sure enough, it took them about a year. And then it was sometime after that the au pair entered into a cooperation agreement. And oh, what a cooperation agreement it is. It's one of the best I've ever seen, where presumably she helped plan two intentional, premeditated murders, and she's going to get time served, which will be about 3 years, and then she'll be deported back to Brazil. It's one of the best deals I've ever heard of. Now, she's not guaranteed the time served, but I want to be clear, the prosecution is going to recommend time served. I think she can get up to 10 years because they've downgraded it to manslaughter. That's all she's charged with. So her max is 10 years. She might do 10 years, but the prosecution is going to recommend time served. And then she gets removed, which is an amazing deal. And that's the kind of thing, it's really the centerpiece of the defense's case. But here's why that's not very helpful. This au pair has been called the star witness. She is, but I don't know that I would call her the only witness, because there's a lot of circumstantial evidence. For example, there's evidence that the bodies were moved after they were killed. There's evidence that the au pair made a 911 call, hung up because it was too early, and then made it 15 minutes later. There's evidence that they two different guns shot the intruder. So let's say, for example,
Hmm.
that the defense convinces the jury, hey, the au pair is lying about everything. Just consider everything she says a big fat zero. That will work in some cases. For example, if I have a drug case and somebody says, "Oh, the drugs were Steve's." Well, you're a cooperating witness. Don't believe anything he says. On that issue, that may be enough to win the case. This is different because there's all this other circumstantial evidence that even if you completely disbelieve the au pair, doesn't make sense. Why, if they were both there, would you move the bodies? Why, if they're both there, do you use two different firearms to kill the intruder? Why, if they're both there, does the evidence show that the husband was apparently waiting at McDonald's to get a call from the au pair, who was, oh, by the way, the ruse was so elaborate and clumsy in that the au pair would wait in a cul-de-sac, pretend to call the wife and say, or called the wife and said, "Oh, there's a strange car in your driveway." Meanwhile, she knows who the car is. They set this up. And then the husband comes galloping in from McDonald's to save the day. I should add that he was a law enforcement agent with the
Oh,
IRS. So he had
no
a service
way.
firearm.
Oh my
So
God.
he had
Okay.
a service firearm. And then in the weeks before, he bought her a Glock and they went shooting at the shooting range. So, like, all right, so you disbelieve everything the au pair says. There's plenty of other evidence
I have
that
so many
doesn't make
questions.
sense.
Does any of the physical evidence point to her doing the killing?
Oh, definitely. In fact, she admits that she shot the intruder guy. I call him the intruder. He wasn't, but the
The
I guess
guy that they accused of
the
in
patsy, yeah, the guy they wanted to foist all the responsibility onto that they suckered
so
into.
she killed somebody.
She, I think, according to the evidence, finished him off. The evidence shows that he was initially shot by the husband and then she finished him off. But the stabbing of the wife was done by the husband.
I think that's really important to the case because you could see a situation where she's sort of, she's from another country. These are the only people she knows. She's very young. She's manipulated by this guy. She could make an argument. Maybe she was terrified of him. Maybe he made threats against her, whatever. You could see that as her defense building,
Hmm.
right?
Sure.
Minimizing her culpability. But once she actually partakes in the killing, a sentence of time served and being deported just seems real
It's
small.
not even manslaughter in my view. I mean, how can that be manslaughter? Manslaughter is traditionally an accidental but criminally negligent killing.
No,
Nothing accidental about this, but
no,
and the rule of plea bargaining is that, and DAs have told me this many, many times. It has to fit the facts. It can't just be an imaginary lesser
right.
charge. There has to be some basis in fact for accepting a plea. So you can't just, hey, can we just call this a DUI? It's not a DUI. It's manslaughter. It has nothing to do with cars.
You've seen many people go through our criminal justice system who have done way less, in an accomplice type of situation where, they're part of a gaggle of people who kill someone, or they're part
Sure.
of, a murder, even if it's planned, but they're not the one pulling the trigger, they're the one standing by the door, and those people get tens of years. Those people get lots of time. And people go up in arms about that, like that they think that they should sometimes they'll fight for more time for anyone who was involved and anyone who was an accomplice, anyone who had anything to do with it. Sometimes they'll fight for less, but this just seems like a real extremely
Oh
low
yeah. I mean, if you're
sentence.
in federal court and you're an accomplice or a co-conspirator, you
Even
may
to
not
like a
have never
bank
handled a
robbery.
gun.
Yeah.
Yeah, you may have never handled a gun, but if a gun was involved, you're probably looking at you are looking at a mandatory minimum sentence, and that's, I mean, this happens in state court all the time too. So you're absolutely right. I mean, for essentially admitting that she was a co-conspirator to planning the assassination of two innocent people to get time served 3 years, if she gets that, and then removal back to Brazil where she can start fresh, it's an amazing deal. And look, here's the thing about cooperating witnesses. I've had to deal with them. I have them in a lot of my cases. And the challenge is this: you can always show that they have credibility issues. After all, almost by definition, a cooperating witness is somebody who has their own culpability. If they're just some eyewitness on the street who's totally innocent, they're not a cooperating witness. So they have credibility issues. You point out that they're here because they're getting a deal and they want to get the benefit of the bargain, and the deal they have is with the prosecution. And you try to do that to show that they lack credibility. But here's the thing, and I have to admit this, and this is what prosecutors will say in their closing, essentially some version of, look, we didn't choose this cooperating witness. The defendant chose this cooperating witness, the au pair. It takes a criminal to catch a criminal, something like that. And juries get it. Juries understand that. So, as much as you may muddy up a cooperating witness, you really got to have concrete evidence that they're lying, or else the jury is likely to believe them. Because, look, I think they believe what common sense tells us that criminals hang out with other criminals. And, criminals are probably the best source of information about what other criminals are
That's
doing.
fair.
The
That's fair.
problem is
But
they're unreliable.
does the jury know what her deal was when they're considering her credibility?
Not only do they know, it's one of the central themes of your cross-examination. And in fact, what the prosecution did, and this is the smart thing to do, they get it out on their direct. You've got to do that, or else it's going to look horrible if you ignore the fact that she has a deal. And the other ways they insulate it is that they make
Sometimes
the
they don't
deal very
finalize the deal until after, right?
exactly. They always
Yeah.
put off sentencing until after,
Yeah.
so they haven't actually. It's a clever little thing that prosecutors do, where they really the deal isn't as hard and fast as it sounds at the time of trial, so they can truthfully say, I don't have any ironclad deal with the prosecution, and then. Of course, when they get to sentencing, then that's when they get the benefit of their bargain. That's why cooperators almost routinely are not sentenced until after they've delivered their goods.
I wish we were in person today. We're not in person today because we're going to do some of these in a remote setting, just audio only because of our crazy schedules. But you will appreciate I broke a nail while you were talking about this. You always have a nail file or a pair of clippers on you. And I'm sitting here with this broken, jagged nail and talking to my husband, but it doesn't matter because you're not physically able to hand me your nail file. And I'm super frustrated.
I'm sorry. I'm sorry.
One last thought on this case. Why isn't it getting more attention?
I wanted to, and we're going to open another can of worms here.
Hmm.
I have been wondering about that. One of the things, and I think this is something that you do very well. It's part of your job, but I've often thought over the last decade or so, what makes a true crime story catch fire? Because there are crazy stories going on all over the country every day. And what makes a story catch fire? And one example of that, and I think this is where you're really going to get passionate. Karen Reed, the recent Boston trial of Karen Reed, in which she was acquitted the second time around, that to me was a DUI homicide, and I don't know why it became
Oh,
the
because it was a
national
who done
phenomenon it did.
it. Because it was a who done it. Because
Right.
it wasn't I think a big part of it was her defense being this was a cover up, conspiracy, a cover up. The cops, who are supposed to protect us were the ones who killed one of their own. Like, I think that is a big part of what makes it's different. It's novel.
It stands apart from other
It's
cases.
thank you. It's
But
interesting.
can I respond to that? If defense attorneys listened to every client who told them that the drugs were planted, or that, this was a pretextual stop, or the cops had it in for me, or they made all this up, if we actually engaged in those theories of innocence, we would, none of us would have jobs. Every criminal
But
defendant
that's not
comes
the
up with,
standard for media.
I understand.
You're
So,
asking what makes it take off. It was the
yeah,
internet sleuths that made the Karen Reed case take off. And I don't remember the guy's name, but there was like one guy in particular who really went hard for her on the internet. And that community does look for these sort of sensational, crazy sort of theories about what happens in what the alternative theories could be for a crime. And that was one where, you and I argued a lot about that at the
a
dinner
lot.
table because I didn't think it was that crazy of a theory, but given the facts of the case, and you did think it was a crazy theory. But uh I think that
Anyways,
that's what lit up the internet. I
yeah.
think that
So
that was what
why do you think this case hasn't lit up the internet? It's got everything. It's got au pair. It's got sex. It's got a bizarre theory of criminality. It's got everything, and yet it hasn't caught fire the way Karen Reed did, occupied everybody for years.
what
Or
state was
even
this in?
Brian Koberger, which was, the Idaho murders, which is just some gruesome stabbing. Don't get me wrong, but gruesome stabbings happen every day. I've handled a few of them.
I don't know, Danny. That's an interesting question.
Yeah.
What state is it in?
It's in Northern Virginia.
Are there cameras?
Yes, the whole
There are
thing's
cameras in the
televised.
court?
Yeah.
That is fascinating. So like court
So
TV, is
so
court TV there?
I believe they've been covering it. I don't know if they're covering it gavel to gavel. So yeah, I don't know. I don't know why it hasn't caught fire. It's a crazy, crazy set of facts. And in my view, there's very little chance of an acquittal. I mean, a lot of cases I'm 50-50 on, not this one. This one seems like a foregone conclusion.
Yeah, I don't know. I don't have an answer for you other than like maybe just the media cycle is so packed right now. Like the news cycle is just so wild that this
Definitely.
fell through the cracks. I don't know. I don't know. Here's one that I also didn't think got enough attention or didn't get as much attention as I expected. Federal prosecutors announced on Thursday charges against 26 people, including more than a dozen former and current NCAA Division I players and at least one former NBA player. They allege this cheating scheme that influenced at least 29 games across 17 schools during the 2023, 2024, and 2024, 2025 seasons. They're saying that fixers and players were involved in this vast point shaving and game fixing scheme, and that these games were rigged for gambling profits. According to the indictment, which was just unsealed, authorities say gamblers recruited college basketball players to intentionally underperform, that's the point shaving,
Hmm.
in exchange for bribes, and then placed bets against those teams in order to profit. And the bribes allegedly ranged from 10,000 to 30,000 per game. So the first time I read this, I thought, okay, I know you're going to say I'm a defense minded, whatever. But
You
how
are
do you prove that somebody didn't just have a bad game? How
right.
do you prove, if everyone could play exactly the way they wanted to in sports, then people would always be winning, right? They'd always be playing at their best. So how do you prove that somebody intentionally played poorly? And I'm guessing what the answer to that is that the money, you follow the money. Like once they
Exactly.
receive the bribe, then you know that there was some culpability. But still, how do you prove that they intentionally lost or intentionally played poorly? It just seems
Right.
like only one part of this is really concrete and the other part of it is kind of wishy-washy.
So your question is a great question. It kind of goes to the core of really all criminal cases, which is this. Every crime includes an act element and a mental element. And one of the legal fictions is the idea that we can never prove conclusively what someone was thinking when they did something. We can't, right? In almost every situation, unless somebody writes out a signed confession, we're using circumstantial evidence. We're drawing inferences of intent because people don't get on the stand and admit I intended to kill that person. In fact, they do just the opposite. Everybody says it was a mistake or it wasn't mine. Those weren't my drugs. That wasn't my car.
This is where motive comes into play,
Well,
right? In
motive is
certain
different. Motive is why we do things. Motive is not an element of crimes. It's an element of a very narrow set of crimes, like hate crimes, almost so statistically not significant. Motive is evidence of intent. Motive is never an element of a crime, with those exceptions I just mentioned. But prosecutors love motive evidence because it's so devastating. So they're always going to introduce. In fact, prosecutors will lament, hey, man, I don't have any motive evidence. That's the problem. And I would love it because it helps the case. Even though it's not a required element, good prosecutors know that motive is important. Now, a lot of times motive's easy. I wanted to make money. That's why I robbed the bank. I was angry at my wife. That's why, I went there and committed an act of domestic violence. So motive is a critical part of cases, but strangely enough, it is not an element of the crime. You don't need motive to prove a case, but prosecutors want motive evidence. So I love your point about how do you show if somebody intentionally threw a game? I'll start with this. I've always thought point shaving in team sports is the dumbest kind of gambling to get into because let's say you're one of five guys on a basketball team and you're shaving points. What do you do if your teammate decides to have the game of his life and you're actually playing against your teammate? You can't guarantee the sports that you can guarantee shaving are one-on-one sports. Sumo wrestling, right? Let's see. Uh, uh, let's chess. I'm trying to think of silly one-on-one sports. Fencing. Those are all sports you could definitively and absolutely fix. But
I don't think you
basketball,
should say that fencing is silly
I'm
or
giving silly examples just to sort of make
sumo
them stick.
wrestling. I don't want to get a bunch of hate mail from sumo
No, no, they're
wrestlers.
not.
That would
I'm
not
giving
be.
I'm giving actually what the example I'm giving isn't all that silly. I have read that sumo wrestling has at times had an alleged gambling problem, and the reason for that is obvious. I'm trying to give sort of fanciful examples. That's probably a better way of putting it. But individual sports are easier to fix. A team sport like basketball, you could totally try to shave points and then end up your other teammates carrying your weight, or maybe you get benched and they come together and do and actually win the game. Then you're in big trouble.
This is
But
not a legal question, but why is basketball always involved in gambling sagas? Like, why do we always hear about scandal in
yeah,
basketball? Like,
the
do you know what I mean?
referee,
The
Tim
referee, there's,
Donaghy,
yes, there,
I,
and that was in Philadelphia too. Like, what's going on in Philadelphia with basketball?
maybe it's because of the team sports. It's one of the team sports with the fewest players on a team, unlike football, where you'd need, you have 11 people on each side. I don't know. I don't know why historically gambling's been big in basketball. So anyway, you asked about how do you show point shaping, and you're right. How do you know if in a particular game somebody dogged it? They didn't try as hard. Arguably, you could never know that, but there's so many other factors, and the way you approach it, you start with the suspicion. Hey, and in modern gambling, and putting aside street bookies, everything's digital and everything is data driven. So you can look at spikes in betting on an underdog, for example. And one of the things they watch closely is where the bets are. It's how they set the spread. So if you see a huge spike in bets for East Ham Sandwich University to not cover the spread, well, that's going to be an indicator. And then you look at the team and say, well, who underperformed? And that's not going to get you to a conviction. But then if you get search warrants, you get subpoenas for text messages, and then you build your case around the communications. But you're absolutely right. Can you secure a conviction simply by showing that an NCAA basketball player wasn't jumping as high as you know that he
Yeah,
can jump or
didn't
making as
score
many
as
three
much,
pointers? They
didn't
would
run as
never
fast. Like, how
that
could you
would
do
never
that?
be the key evidence. That once they suspect,
So it's got to be
and by
like
the way,
text messages and bank
exactly,
accounts, right?
exactly,
But
meetings,
still, don't you need the actual crime is not text messages and bank accounts,
it's the
right?
shaving.
It's the shaving. So you need evidence, you need proof that they didn't perform. What do? You compare it to like previous games that where they did perform? Like how do you prove
Here's
that?
how I think you do it. You make the performance a very small part of the case, and you allow the jury to draw an inference. So you show that, you're right. I mean, is it proof that somebody shaved if they average 8 points a game and in this game they had 4 points? Um, no, that alone is not proof. But together with the text messages, with a known bookie, and the sudden amount of cash found in his home, and the spike in betting on the under for that team,
Just a little
uh,
weak for me. It's a little weak.
well, it's powerful
He could
circumstantial
have been
evidence.
dealing drugs to get that money. He
Well,
could
then
have been.
then so how let's say for one of these players they find that he came into, several thousand dollars and texted somebody for that several thousand dollars and got the several thousand dollars, and that someone who gave it to him bet on the under heavily and made a lot of money, then I think you can look, it's all circumstantial, but circumstantial evidence is often more powerful than direct testimony about what happened, eyewitness testimony.
I want to
So
get on one of these juries. You
yeah.
know, it's like a big regret of my life that I've never been put on a jury. I'm really upset about it.
Well, I've always said you'd be a far better defense attorney than I am because you question absolutely everything, and I even sometimes have a tendency to sort of not notice things that are critical. But I guess also I've become a little jaded
Hun,
in
you pay
handling
the
so many
bills, so
cases
I
over
need
the
you
years.
not to say that. I need you not to say that ever
What?
again. Thank you.
Say what?
That you don't notice things. You're a criminal defense attorney.
No, I know.
That's how we live.
Right,
So please
right.
don't
I
say
can't I
that
can't
publicly.
broadcast that.
Yeah.
So we'll clean that. We'll clean it
He's
up.
actually incredibly smart, everyone, and thinks about all of these things day and
Carefully.
night, never
Yeah.
sleeps, up all of the time, and any gaps are filled in by me, so don't worry about it.
Thank you. So look, I think these are provable cases, but you're right. I mean, what you're talking about is it's probably more visible because we're talking about physical performance in a basketball game. But after all, the chemicals that make up our thoughts every day in court, we're using circumstantial evidence to prove beyond a reasonable doubt what these thoughts were in your head. And routinely defendants say that's not what I intended, or that wasn't, self-defense is a good example. We Since we do not yet have the technology to download conclusively what's in our brain, we use circumstantial evidence to prove intent. I would say in most cases, because most criminals don't write down, I fully intended to rob this bank.
Yes, but in with most crimes, the fact that you whatever was in your head doesn't matter, right? The fact that you did rob the bank is all that matters. The fact that you did kill the person is all that matters. The fact that you were drunk when you were driving is all that matters.
Sure.
And in this case, playing a game is not predictable. It's not a concrete thing that you're going to win. It's not a given. You play sometimes a person who played fantastic yesterday tries just as hard and has a crap game the next day. It's not a guarantee, you know? I just that's where
Right.
I'm a little hung up. But
No, you're right. But that, again, that's why I think the actual performance or subpar performance is a small, small element of the crimes. And if you're a prosecutor, you're not going to go to a grand jury with just the fact that, Bob Smith played a poor game on such and such a date and he should have played better. You're going to go with a ton of text messages. You're going to go with cash that he somehow came into. You're going to go with his connections with shadowy underworld figures and bettors, and you're going to look at the data and show that there was a an unexplained spike for the underdog. Always the underdog, right? It can't be for the favorite, or it can't be to win. It can't be to for your team to win because that you can't control. Arguably, I mean, in my view, I don't know that you can control just by one person point shaving the outcome of a basketball game, especially if you get benched or hurt. What do you do? That's always struck me as a very strange way to make money gambling.
what's your second story?
My second story is the search warrant executed on a Washington Post reporter this week. And you, as a scholar of journalistic ethics, I really wanted your take on this before we get into the legal aspect. That the Trump administration, not the Washington Post reporter, was not a target. In other words, she was not suspected of criminality herself, but instead, it was in service of obtaining evidence against a former government worker who's been charged now with leaking secrets. And I want to hear what you have to say about it, because I'm sure I think I know where you're going to go.
Well, let me just start by saying I'm a reporter who's been subpoenaed more than once, and it is the worst feeling. It is so
Sure.
unfun because, we enter into these relationships with sources where we make promises like, what's on the record and what's off the record, or what's on
Of
background,
course.
and what we're not going to share with people, with even our editors, and certainly not with public, and certainly not with law enforcement. And we do the, we make those promises with the belief that there are certain protections for us. There are shield laws that generally speaking, and I know it changes in different jurisdictions, but generally the idea is what's in your notebook is protected. What you put out into the world is not, but what's in your notebook is protected, and that we don't have to do things like call the authorities when someone tells us, that they committed a crime. And so it's really uncomfortable when you are told by an authority, told by a judge, told by law enforcement that you have to break that promise that you made to a source. It's like it's our currency. It's the only thing we have is the trust that we have with our sources, and to be able to say, I've never broken that is huge. And so it, for lack of a better word, like it sucks. And I felt really bad for this reporter, and as most of those of us in our industry did when this news broke. And every time news like this breaks, it's like, oh, it really feels like an abuse of power in that way. But I know you're going to tell me that shield laws are weaker than I think they are. So tell me all the
Actually,
ways I'm
you'd be
wrong. I'm
surprised.
prepared to be told I'm wrong today.
No, no, both federal law, a law passed in 1990, I believe, the privacy oh, I can't remember the Privacy Something Act, but it is designed to create a statutory and a regulatory preference for subpoenas instead of search warrants when it comes to newsrooms. I don't know how that translates specifically to homes and home computers, but I mean, let's face it, the modern newsroom, since everybody works from home, the since 1990, the idea of a newsroom has changed dramatically, and even what a journalist is. Your newsroom is your office, or sometimes your home, or really your newsroom is your laptop. So to the extent there's procedural differences there, I'm not sure. But no, I actually think what the government did here was arguably overstepping its bounds. I expect there's going to be some motions to quash or challenge this search warrant. But the problem is, and again, I go back to this point that this administration is very good at finding loopholes. Once you've already executed the search warrant and obtained the information,
Yeah, they already have the
you can't
info.
put
It
the
doesn't
toothpaste.
matter. Exactly.
Right.
They
Right.
already violated, they already made it, which I know is their goal, the administration's goal here. They've already made it so the next whistleblower thinks twice. The next person says, I probably shouldn't get this information to a reporter because there's the probability of getting found out is higher. And
you
that's what
bring
they
up a
want. They want the fear.
I'm so glad you brought up that word whistleblower because could you imagine wanting to be a whistleblower in this administration? And what's
Nope.
funny is you go back to the original Trump administration, the first one, post 2016, that administration was chock full of whistleblowers and leakers and it was almost on a constant daily basis. Doesn't feel that way this time, and it feels very scary for anyone who is in the administration who would speak out against them because they've clearly made it their priority to go after those folks as they have in this case. They are not kidding around. And by use of a search warrant, you can't unring the bell once they've obtained the devices and all the other information they need. Even if you end up suppressing the evidence, once the DOJ or FBI has the information, they can't forget it.
Right.
So it's a hollow protection. But no, I don't think I think this was very problematic, and it I think it may have violated DOJ's at least policy preference for using subpoenas instead of search warrants when it comes to newsrooms.
And so the reason that they searched this reporter's home is because the information existed only on her local device, right? Only on her phone, because it was a signal conversation. Is that
Yeah, I
is
believe
that
right. And
true?
as you know, with Signal, the only way to look at the communication is to actually have the devices
Have the
because it's
phone.
end
So
to
they
end.
they were after her physical phone.
Right. Well, and I guess probably I don't have a MacBook, but I guess you would be able to do the same thing on a MacBook. Maybe not. I don't know. But I imagine that's why they went for the devices.
So I guess the lesson is you got to purge that physical evidence, right?
Yes,
If
for
you're a
journalists,
reporter,
but
yeah.
lawyers, we can't. Lawyers, we have a duty to maintain records and communication. So
But
don't
we
have
don't.
the luxury
We don't.
of deleting our inbox the way a lot of people do who stay organized.
PSA, though, we don't,
Right.
right? We don't. Yeah, I hate those stories, obviously, for personal reasons. All right, my last one, I think is right in your wheelhouse. Renee Good, the 37-year-old Minneapolis mother who was shot
Yes.
on January 7th by an ICE agent. Her family has retained the Chicago-based law firm Romanucci and Blandon. Am I saying that right?
I think so. Yes.
It's the same firm that represented George Floyd's family, to conduct a civil investigation. They have not yet filed anything, but a civil investigation into her death, pushing for transparency about what happened that day, including why agents were in the neighborhood and how exactly the encounter unfolded. I think it's interesting that they are announcing this before filing a formal lawsuit. And I initially thought, well, that's probably because they think a lawsuit's going to get tossed pretty quickly because of sovereign immunity, right? And so they're just doing this like investigation that sounds important, but is simply just
Right.
people with a lot of resources doing their own sleuthing, right? Is that what's going on?
It's not sovereign immunity. It would be more qualified immunity. And here's the bottom line. Suing the federal government or federal law enforcement agents is so difficult. One strand of that is called a Bivens claim, and it is so difficult, it could scarcely be said to even really exist because they have so many protections. The short version of it is that this is a lot different than George Floyd. George Floyd was a local police officer. It's easier to sue local police. Um, this is also there was a clear finding of guilt on many levels in the George Floyd case. There is likely to never be a prosecution, and if there is, that might set up a constitutional crisis because I don't think the federal government's going to let Minneapolis prosecute this ICE agent. But whatever the case may be, this would be a really, really difficult civil case, which is likely why they're taking the case now the way we often do in the plaintiff's world for investigation. So they may get some publicity out of it, and then maybe in a year they'll quietly tell the clients, "Look, we don't see anything there."
Oh, wait, you think this happens a lot?
Oh yeah, absolutely. There are many high-profile
Wait, is
cases.
this kind of scammy? Is this like, we'll take your money, we'll investigate, and then we
No,
want
no, 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 because they'll do it completely contingency. And if something comes up, if let's say, for example, it's a good business practice. You've said, look, we'll investigate. If there's something there, great. And they've gotten the benefit of some free publicity. And then maybe quietly in a year, they say, look, we hoped there was nothing that came up. We're going to have to let this case go.
There's so much more in the way by way of developments in this case that we will talk about probably next week because you have a show to host, so you've got to go.
I do. I'm heading over to NBC right now.
Do we say bye guy at the end if you say hey guy at the top? How does that go? What does Mr. Caddy say?
Oh, wait, I don't know, but I think we should evolve it into
Into
bye
like
guy.
see you later guy.
Yeah, bye guy.
See you at dinner guy. See you at dinner.
See you at dinner, guy.
See you at dinner guy.
And let's go out tonight. All of us.
Really?
Yeah, why
Okay.
not? Let's
Oh,
do it.
that's so fun. I don't have to cook. That made my
Yep.
day. Amazing. Okay, see you at dinner guy.
See you at dinner, guy. Bye.
Bye.